Yes, sir.
And is Deputy Zimmer remain employed by this agency to this date?
Yes, sir.
Now, let me hand you what has been the report that I've been given and was told this represents the internal affairs file of Anthony Zimmer pertaining to an incident that occurred on August 13, 2010. That appeared to be the internal affairs file with respect to that event, sir?
Yes, sir.
Okay. Now, what I'd like you to do, if I can, is turn to tab 1 of that document, and that's going to be the report of investigation. Can you see that there?
Yes, sir.
Now, or Deputy Zimmer, I should say, was charged with misdemeanor injuries to the department.
Yes, sir.
And also violation 86-45313, conduct on or off duty that reflects unfair to Williamson County. You
Yes.
see that?
Yes.
Now, tell me if I'm wrong here, sir, but didn't Deputy Zimmer, the offense that led to the misdemeanor injuries to the department sustained finding, incident was he punched a juvenile in the face 3 times and broke his tooth?
Yes, sir.
Okay. Now, is that the type of conduct that you want your deputies to engage in?
No, sir.
I assume you agree with me, it doesn't speak well of your organization for one of your deputies to engage in that type of conduct.
No, sir.
In fact, I can't really imagine a more serious type of conduct that one of your deputies could engage in. Would you agree with me?
No, sir.
Than battering a child?
Mr. Deane.
Okay, let's talk about that. You agree with me that Mr. Zimmer punched a juvenile in the face 3 times and broke a tooth, correct?
I'm gonna object to going into the facts of a case that's not before you. If he wants to compare the disciplinary letters, which have the facts that the sheriff relied upon in disciplining Zimmer, that's one thing, but to go into the complete internal affairs investigation of Anthony Zimmer is not appropriate. If he wants to compare the letters of discipline, then that's appropriate for consistency purposes.
That's all we're authorized to handle.
Ma'am, let me read from your own rules, and then you can renew your decision. One of the things that you're charged to do,
What rule are you reading from?
I'm reading the Personnel Board Rules, page 10 and 11, and I can, I have a bait stamp copy
I have.
for each of you. There you are. There you are. There you are. And there you are. Now, as I said, beginning on page 10. It states, hearings on appeals for disciplinary actions are conducted for the purpose of determining whether the employee committed the acts alleged to be the cause for taking disciplinary action as the basis for the appeal, whether the service group's actions in disciplining the employee conform to the Volusia County System Merit System rules, whether any evidence exists in defense, mitigation, or extenuation of allegations, and fourth, whether disciplinary action was appropriate under the factual circumstances of the case. The rules go on to say, on page 23, under, let's see, propriety of penalty. The board's determination as to whether and to what extent the employee was guilty of the charges will determine the question whether the punishment assessed by the service group should be upheld or modified. The mere fact that a somewhat different penalty or a somewhat more severe penalty was imposed by the board member would have been made had he or she been the decision maker originally is not sufficient to justify a recommendation of a different penalty. The board should not substitute its judgment and discretion for the judgment and discretion exercised by the service group director if the service group has demonstrated that it acted in good faith upon a fair investigation and has imposed a penalty not inconsistent with those imposed in like cases. Your responsibility is to assess whether or not the penalty imposed on Travis Deane was overboard in view of similar cases. I presented one case already where another deputy was charged with, through IA, with misdemeanor injurious to the department. He was not terminated. He was suspended after punching a boy in the face 3 times. I am entitled to this line of testimony, entitled to you to consider it.
Are you still,
I'm responding to the objection.
okay. Sounds like you're testifying.
No, ma'am. Legal argument.
Okay.
Testifying about if I were to offer facts in this case. That I'm not doing.
Okay.
As you know from the facts in this case, there are things that come out through an internal investigation that may or may not be sustained. So your consideration should be limited to what the sheriff suspended Mr. Zimmer for. What were the facts that were established by the internal investigation, which there's a 3-page letter. I had absolutely no objection to that being placed into evidence for your consideration for consistency and comparison. But what the other factors that were developed during that internal investigation are no more relevant than some of the things that we have not gone into that were in this investigation of Mr. Deane.
Oh, that's
for consistency.
just flatly ridiculous. The decision made by
Is
the
that a legal
sheriff.
argument?
No, that's just
Okay.
histrionics.
Okay.
The decision of the sheriff with respect to Anthony Zimmer was based upon the internal investigation that I've already provided to you and to the sheriff. How do you consider one without the other? We need to know the details so we can assess the punishment given by the sheriff in those circumstances. I mean, I'm just surprised I'm getting an objection. I know why I'm getting it because she doesn't want to talk about it. She doesn't want it to be heard. That I get. But there's no legal basis for the objection that she's made. And I ask you to allow me to proceed with this, and I'll try to be as quick as possible about it.
I have a question. Is comparison to Zimmer, is that something that we can look at here?
You can consider consistency in discipline it's generally at the point where you're determining whether the penalty was appropriate in this case. So for consistency, yes, you're allowed to look at other letters of suspension or other terminations of other people for like offenses. The comparison here is that Mr. Zimmer was charged with misdemeanor injurious to the department just as Mr. Deane was. So from that perspective, that's a fair comparison. My objection is that what was developed or what is contained within the internal investigation of Mr. Zimmer, that is not part of your responsibility to go behind what the sheriff found was sustained in the letter of discipline. That's the purpose of the letter of discipline. That's the final action, and it details the facts that the sheriff relied upon, just like he did in this case when he suspended Mr. Zimmer.
Well,
I
certainly,
understand. We've always done it that way.
ma'am, with all due respect, what's your ruling before I proceed? I'll ask you to reconsider it if I think I know what it is. But
I'm
go ahead.
asking you to consider the letter of suspension and not go beyond that into the internal investigation of Mr. Zimmer.
This is
That's not appropriate.
absolutely preposterous. If this board is prepared to rule that I can't go into the IA reports with respect to these offenses, then I won't need to demonstrate bias, you will. This is absolutely ridiculous that I can't go, that I'm being told by opposing counsel that it's inappropriate to go into the bedrock of the allegations against these officers upon which the sheriff made his decision. She doesn't want it to come out because she knows it's inconvenient facts. I know that a deputy punching a boy in the face 3 times and chipping his tooth over someone egging his car, that's a very inconvenient fact. But it's the fact.
That's something that you're testifying to. That's misrepresenting what's in the internal investigation. If they want to read the entire internal investigation, then certainly we can sit here while they do that.
Fine.
To
Well,
determine
do
the
we agree
facts.
that he punched a 17-year-old in the
No,
face
we
3
do
times?
not agree with that.
Okay, well, then why was he, just curious, why was he found guilty of misdemeanor injurious to the department, if that's the case,
He committed a battery.
on a juvenile?
We're not, this is not the proper method for handling this consistency.
What's the proper method is let me present my case without undue interruption and ridiculous objections. I'd be asked,
I take exception to your calling my objections ridiculous with some of the things you have raised here today.
well, I guess we can agree to disagree then. My point is I should be allowed to present this evidence, not be hamstrung by opposing counsel or this board.
I've made a relevancy objection.
Relevancy.
Rule on that.
Reasonably calculated discovery of admissible evidence. Well, certainly, that's the relevancy standard. What these deputies did is the whole ballgame. My case is largely built on the fact that there was inconsistent discipline. That this deputy doesn't object to the notion that he committed the offense of open house party. He doesn't object to the notion that he texted while drunk or that he used David when he shouldn't have. What he does object to is the penalty of discipline when other deputies before him weren't given near the discipline despite a more severe offense.
That's your opinion of what the
That's
other
what the evidence
offense
will
was.
prove. And I will try to prove if he'll let me.
Well, the sheriff considers more than just that. He considers their personnel record,
We can talk about that if he
Yeah.
wishes.
past performance, when he's doing that. I'm gonna side with the county because personnel board only gets the front several pages of any termination and appeal. We don't get IA reports and all that. That's brought into evidence.
I'm curious, don't you think you should have all the facts before you render a rule in my client's future? Are you telling me you don't want to?
Sometimes they're redundant.
Well, you know what? Then maybe you should hear the witness's answer on these questions. You can judge for yourself whether they're redundant. I take obsession to your ruling. If it stands, it stands. I'll deal with it down the line. But I'm shocked. Really shocked.
Sheriff Johnson, do you want to answer that question?
You already answered the question.
Up to the county attorney, do I have
You
something?
can answer any question that's not objected to and ruled inadmissible by the board, Sheriff.
I'm beginning to sense the utility of continuing, but I start what I finish. You agree with me, I think, for the back and forth, that Anthony Zimmer punched a juvenile in the face 3 times.
Yes,
And for that, you found him a sustained violation of the offense of misdemeanor injurious to the public.
yes,
And the misdemeanor you found him to have violated was battery.
yes,
Okay. Battery is a first-degree misdemeanor, right?
yes.
Now,
Now, but there's a caveat to that. It's the fact of, he knew he was dealing with the juvenile, Anthony Zimmer did not know he was dealing with the juvenile.
and you know that house there? Because Anthony Zimmer said so?
There, the people there, yes, from what happened there, they did not know for a fact that it was a juvenile, and didn't know the individual in advance, where
So,
Mr. Deane did know the juvenile in advance to the David.
you feel the offense of not giving, that wasn't proven, but allowing by omission a minor to drink a sip of beer and maybe a Jello shot in your house where no one got hurt is worse.
We had to know the drink.
Sir, that you already agree with me that the finding that, or the allegation that he provided an alcohol himself wasn't true because that statute wasn't violated. You've already testified to that several times.
That's not.
No, I didn't say that.
Yes, you did.
No, I didn't. If I did, we got to correct that. He was